Welcome everyone. We're just waiting for everybody to get through, and then we'll be with you all in a moment. There's lots of participants coming through. It just takes a bit of time. Right, we'll get started. Welcome to day 4 of Family Mediation Week. I'm Sarah Manning, Chair of Family Mediation Week and a partner at Hall Brown Family Law, where I work as a family solicitor and mediator based in Leeds. This session is being recorded and will be available on the FMC's YouTube channel. The link is on the last slide. Please post any questions in the Q&A box so that they can be answered at the end after the slide presentation. It's my pleasure to introduce you today to two outstanding speakers. If we could just start the slides, Elaine Richardson, Tristan Harvey, who are both co-chairs of Resolution's Dispute Resolution Committee. They'll be discussing how to unlock the power of mediation and to maximise success in the mediation process. As a mediator myself, I know all too well how seemingly small issues, often easily avoided, can derail mediation, leaving participants into costly, lengthy and acrimonious court battles. Next slide, please. Just introducing our speakers, we've got Elaine Richardson, who's an experienced solicitor, collaborative lawyer and mediator at Richardson Family Law. She specialises in hybrid and child-inclusive mediations and is also a recognised expert and trainer in domestic abuse and high conflict with a trauma-informed approach to family law. In addition, Elaine is a professional practice consultant and a family law supervisor, which means that she supervises other mediators and lawyers. Elaine works with clients across the country and abroad, and most of her work is online. Next slide, please. We've also got Tristan Harvey, who is an experienced barrister and mediator specialising in family law dispute resolution at Queen Elizabeth Building. He is accredited by both the Family Mediation Council and the Centre for Effective Dispute Resolution. And Tristan is also an arbitrator in financial and children cases and conducts private FDRs and nearly neutral evaluations. Tristan also sits as a deputy district judge. Next slide, please. So what to expect in today's webinar, we'll be covering key topics including changes to the family procedure rules, the MIAM, a golden opportunity in the mediation process, the flexibility of mediation and its integration into family law, and also a practical guide for solicitors and defining success in mediation. Next slide, please. And over to you, Elaine, to get started. Thank you.
Thanks so much, Sarah, and hello, everybody. It's great to see so many of you here. Before we start on our practical tips for effectively supporting your clients through mediation, I want to speak about the important revisions that were made to the family procedure rules on the 29th of April 2024. So these revisions further shift the emphasis away from the family court towards non-court dispute resolution, NCDR, as we'll be calling it in this webinar. So on this slide, there's a 9-point summary of the new rules, and they're in no particular order, as they would say on Strictly. Although I'm not going to read the whole slide, I want to highlight some key points. So firstly, the new rules widen the definition of NCDR so that as well as mediation, there's now the specific inclusion of arbitration, neutral evaluation, such as private financial dispute resolution process, and collaborative law. So to support this change, the wording on the court forms is changed to NCDR, not just mediation, and the mediator conducting the MIAM will discuss all potential suitable forms of NCDR. So the second point I want to make is to emphasise that the natural gaps in court hearings will be used for judicial nudging into a MIAM or NCDR. So I've just had a recent example of this when an appeal against a financial remedies order in contested proceedings has been stayed by the circuit judge to enable the parties to consider mediation under FPR 3.41a, which provides that where the timetabling of proceedings allows sufficient time for these steps to be taken, the court should encourage parties to A, obtain information and advice about and consider using NCDR, and B, undertake NCDR. So the agreement of the parties to an adjournment for the purposes of undertaking NCDR is no longer required. So the third point I wanted to make is about the beefed up costs orders in financial proceedings for failure to consider attending a MIAM or participating in NCDR. So we're all watching this space, I think, for the case law that will follow from that. There's a new form, the FM5, called the Statement of Position on Non-Court Dispute Resolution, and the applicant and the respondent must each complete their own copy of the form. You'll know that there are questions on the form about which type of NCDR the party has attended, details of the provider, and asking for explanations about why the party is now making a court application. In other words, why wasn't NCDR the right way of resolving the outstanding issues in your case? And if you haven't been to NCDR, why not? So there are pre-application protocols for finance and children and a letter from the president addressed to parents who are making applications to the court about the arrangements for their children. The protocols set out the key steps the court will expect parties to take in relation to NCDR before starting court proceedings. The financial protocol also underlines the duty to make full and honest disclosure. Everyone's required to comply with the terms of the protocols, even if they have not had professional advice from a legal representative. So there's not sufficient time to go into the details about the protocols and the President's letter in this webinar. So we've set out the links in the next slide for you to access if you wish. We could have the next slide, Helen. Thanks. So please take a screenshot or a photo if you wish. You will get the slides afterwards, and obviously the webinar is being recorded. So the President's letter in particular is quite tricky to find, and it is now on the FMC's website in the links and resources page. Over to you, Tris.
Good afternoon, everyone. We're going to start just with the basics, some basics and a definition of what mediation is. And the FMC defines family mediation as a process in which those involved in family breakdown, whether or not they are a couple or other family members, appoint an impartial third person to assist them to communicate better with one another and reach their own agreed and informed decisions concerning some or all of the issues relating to separation, divorce, children, finance, or property by negotiation. So that's the definition, and mediators, I'm sure, will have their own way of describing mediation to their own clients. I sometimes talk about there being four pillars of the mediation process. First is that it's a confidential process, and so what's talked about in mediation can't be referred to elsewhere, and in particular, of course, the options that are discussed without prejudice, and so can't be referred to a judge or an arbitrator if clients need a decision to be made for them. It's a voluntary process, so clients don't have to do it if they don't want to, and they can step away at any point if it's not working in a way they might have hoped. The third pillar is the mediator's neutrality. So he or she is there as a completely impartial person to help clients reach a resolution and facilitate their conversations. And the final pillar is perhaps what might be described as control. So the couple retain the ability to make the decisions, not the mediator. And I'll often say to clients, as soon as people start to move away from mediation towards other non-court options, which may be appropriate non-court options, they just start to cede some of that control. It's in mediation where they retain that ability to make informed decisions which work as best as they can do for them. So that's really the basics of mediation. Elaine.
Thanks, Tris. So you'll see on this slide, I'm going to talk a little bit about mediation information and assessment meetings, MIAMs. I estimate that I do a couple of MIAMs a day on average, and no two cases are the same. And I think of the MIAM as unlocking a golden opportunity, so I'll explain why. Before doing so, I'm just going to go back to basics for a minute. So just to confirm that, of course, a MIAM is not a tick box exercise to sign a court form. It's a tailor-made individual and confidential pre-mediation meeting where the mediator meets with each potential mediation participant. So the two individual meetings take place first before a mediation meeting is arranged. It can be described as a suitability and willingness assessment for mediation, and for the client, an opportunity to speak about client choices and tailor-made solutions. So it's important for you to know, and the public to be reassured by the fact that new standards and guidance for MIAMs were introduced on the 1st of October 2022 and updated in 2024 by the Family Mediation Standards Board of the Family Mediation Council, and the standards align with the recent changes to the FPR. So the rationale behind MIAM is to supply information about mediation and relevant NCDR processes, and to make an assessment of an individual's circumstances so that informed choices can be made about NCDR, support, signposting, and next steps generally. Under the standards and guidance, this is a summary of the outcomes that a mediator must achieve in a MIAM. Firstly, to provide participants with sufficient information about mediation and other NCDR processes to enable them to make informed choices about how to resolve the issues they raise. Secondly, to obtain information from participants about their circumstances and issues arising from the separation. Thirdly, to assess the safety and suitability of mediation for the participants. And finally, to discuss and, where possible, identify with participants their next steps, including the value of seeking legal advice. So we know that it's only when a person feels heard that they can listen. A good MIAM will appear to be a free-flowing conversation and will achieve the outcomes that I've just listed. In other words, it's a skill. The MIAM's the foundation for a mediation meeting, and the focus is on solutions and what to do going forwards, not just dwelling on the problems of the past. So a good MIAM increases the likelihood of achieving a positive outcome in NCDR. A MIAM can result in a mediation meeting taking place, or other forms of NCDR, or not. So if either participant or the mediator doesn't consider mediation to be suitable at that time, it will not take place, and an accredited mediator can sign the required page of the relevant court application form. Of course, as family justice professionals, we all meet individuals displaying high conflict behaviours in our work. Mediators often have the advantage of meeting with both individuals from a separating couple, and a MIAM is the first opportunity to assess for domestic abuse and high conflict behaviours. Safeguarding is the exception to the confidentiality principle that Tris outlined earlier in mediation, and an essential element of a MIAM. So the mediator doesn't share any information about a decision not to mediate made by either participant or by the mediator. Remembering, of course, that the mediator can decline to mediate because mediation is voluntary for all three participants. This is intended to provide protection for the victim survivors of domestic abuse. On the other hand, it is important to know that mediation can be suitable for some cases involving domestic abuse. Domestic abuse is not a bar to a MIAM because each participant will be seen separately. It may not be a bar to mediation either because mediators are trained to assess for domestic abuse situations and adjust the process and model accordingly. So, for example, by offering hybrid mediation in separate breakout rooms online. It's worth noting two further points. If the first participant declines mediation following their MIAM, the second participant can still be invited to a MIAM so that they can receive the same information in an even-handed way. Although, of course, sometimes it's not safe to invite the second participant because of domestic abuse issues. And secondly, mediation can take place in parallel with court proceedings. So that's why I think that the MIAM is a golden opportunity to get to know the mediation participants, to hear their experiences, assess strengths, weaknesses, hopes, expectations, frustrations, and fears. And I'd say that people are usually apprehensive at the outset of the MIAM and finish the meeting more confident in the knowledge that there is a defined next step. Next slide, please.
I'm going to speak a little bit about the flexibility that mediation affords, and there are different ways in which mediation is a flexible option for clients. I'm going to touch on each of these just briefly. First, fairly obviously, but in terms of location, complete flexibility in terms of where mediation takes place. Majority of mediations are likely to take place where the mediator is based, but of course that doesn't have to be what happens, and there may be particular reasons why it would be helpful to have it somewhere else, and that might be solicitors' offices or barristers' chambers, or really wherever it's in the best interests of the clients to have it. I think a choice of mediator is really important, and when advising clients to go into mediation, thinking about who the right mediator is really important, and thinking a little bit about the mediator's professional background. And I'm certainly very open with clients who make contact with me if it's a case coming from a set of chambers that does a range of children and money work, but perhaps a bit more of a focus on money. I might say to clients, if they're coming to me for an all issues mediation, that I'm a good fit, or if there's an emphasis on financial work. But if it were perhaps a high conflict case where the focus is very much on perhaps just the children arrangements, I might say, well, there might be other people out there who have a background who are going to be a better fit. So thinking about who the right mediator is really important. And I think also beyond just professional background, finding someone that clients can trust, and clients can choose a mediator who, on the face of it, ticks all the boxes. But like anything in life, when we meet people, sometimes we have that gut instinct, whether we connect with people or whether we don't. And I always say to clients, it's really important to trust that. And part of the process, I suppose, in starting mediation, I always encourage prospective clients to check with other mediators, talk to other mediators, and see to make sure they're finding someone who they feel comfortable with and that they can trust to lead them through what are likely to be quite difficult conversations. So flexibility in location, flexibility in terms of who the mediator is, and picking the right person for particular clients. Another flexibility, I suppose, is in terms of whether you have one mediator or two, and co-mediation, although this was before perhaps I started to practice as a mediator, was how mediation really started out, and it's gone a little bit out of fashion. It doesn't happen very often. And part of the reason for that is no doubt that it's more expensive to have two mediators than it is just one. But in certain cases, and perhaps where there's perhaps a little bit more money to pay for it, co-mediation can be really effective. And again, choosing the mediators, you could have mediators who have complementary skills and can really help clients unlock a particular case. Flexibility in relation to whether or not the mediation takes place in person or remotely, and this simply wouldn't have been part of this talk 5 years ago. And of course, COVID has changed things completely in the way in which we work. And that choice as to whether or not mediation is in person or remote isn't a binary one. And sometimes, depending on where people are located, if I'm mediating, we may have perhaps the first joint meeting in person. If we're dealing with financial disclosure, we might perhaps do a couple of sessions where we do that remotely, and then perhaps come back together to talk about options and what a fair outcome might look like. So again, there's flexibility not just in terms of whether we do things in person or remotely, but whether or not we do a combination of the two. And there could be practical reasons why doing it remotely is a good idea. For example, if people are in different jurisdictions or geographically live in different locations across the country. And I suppose it also, doing it remotely opens up a range of different options in terms of mediators, because your mediator doesn't have to live or work near you. And there are other reasons why working remotely can be a good idea sometimes. So perhaps in higher conflict cases, it might be that it's safe and appropriate to have clients in the same room remotely, but where they would feel uncomfortable, it wouldn't be appropriate perhaps to have them face to face. So again, thinking about how the mediation is going to be set up is really important. And then finally, whether it's lawyer supported or not. And any mediation can be lawyer supported, not just what we've come to describe as hybrid mediations. And again, it's not a binary choice. Sometimes it's a good idea to have lawyers supporting for part of the mediation, but not all of it. As to hybrid, this is a separate talk in and of itself. And as it happens, Elaine and Sarah, I think a few days ago, did a talk just on hybrid mediation, which will be available. So I'm not going to spend any significant time talking about it. But the essential difference in hybrid mediation is the ability for the mediator to keep confidences when the clients are in separate rooms. And that can sometimes be the key to unlocking mediations. It's more likely to be lawyer supported if it's a hybrid mediation and perhaps take place over a longer period, perhaps a half a day or a day, and it can be particularly helpful perhaps in high conflict cases and those where the outcome might be more binary. So I use it quite a lot in cases where perhaps we're dealing with trusts of land disputes, or perhaps where there's a claim under the Inheritance Act. And one of the great things about it, I think, is the complete flexibility of the hybrid way of mediating works, and being able to bring people together in completely different combinations. So sometimes if I'm doing a hybrid mediation and if I'm having clients in separate rooms and it's technically difficult, perhaps it's a case where the finances are complicated, it's sometimes really helpful just to bring the professionals together. So the mediator and the two lawyers come together, and rather than trying to take messages in between the two rooms, then information can be exchanged really efficiently by bringing together just the professionals. But it provides that real flexibility. And finally, also you can bring, of course, other professionals into mediation. I'm not going to talk about that now. I'm going to talk about that in the context of integration in a moment. So in terms of top tips, and Elaine's going to come back to this, to some of these in a moment, but when seeing clients for that first meeting, thinking about all these things, I think is really important. So not just, is this a case which is suitable for mediation or not, but thinking about where might it happen, who might the mediator be, how might it be held, whether it's in person or remote, and also whether or not it might be helpful to be lawyer supported or not. And of course, these are all things that the mediator is going to be considering in those individual meetings. But I think it's really helpful for clients to be thinking about that in advance of approaching their mediator. Elaine, anything that you want to add to any of that?
Just remembering to unmute mute myself. No, I think that's a really good summary of how flexible mediation can be. And I was just thinking about those first client meetings that you have as a lawyer with your client, and thinking to myself how much mine have changed since I was trained at law college, which I remember was you do this, then you do this, then you do that. And it was certainly not about, it didn't involve listening to the client very much. It was just about all the information you had to present. Whereas I think now I've done a complete about turn, and my main thing is to listen to the client rather than making any assumptions about what's going to fit for them. And also it made me think when you were speaking, Tris, about how important it is to build a team of people around you as a client. So that's not just friends and family. It may be a divorce coach. It may be, a financial advisor. It could be a therapist. So thinking, I think, early on in that first meeting with the client, listening and hearing about their concerns, and thinking to yourself about what sort of team they might need.
Thanks, Elaine. Next slide, please. So I'm going to talk again a little bit about integrating mediation, and that comes in various different forms. The changes in the rules which Elaine's taken us through is going to mean that we're going to increasingly see either mediation running in parallel to court proceedings, or proceedings being stayed in favour of some form of non-court dispute resolution. And it might be, that's something which we'll come back to a little bit later, but judges may well take different approaches in so far as how it's done. And it might be that sometimes judges may not stay proceedings altogether. It's in a case, perhaps a financial case, where there isn't a great deal of money, saying at a first appointment, well, I'm simply going to stay the proceedings, and then you can come back in 3 months for a further adjourned first appointment, may increase costs. And it might be, and this is certainly something that I've done sometimes when I've been sitting, is to give directions up until, so for example, replies to questionnaires and evaluation evidence, and then build in a period of time where the parties can then mediate before coming back for, if they need it, an FDR, and then having some recitals to the order which make it plain that that's what the parties are intending to do. So maybe building it into the court timetable rather than staying proceedings altogether. Different judges may take different approaches. It may be appropriate to stay altogether, but sometimes there may be some directions that the parties might need in order to get them to that point where they've got the information they need to make informed choices in mediation. And so there's going to be that integration as between mediation and the court process. But I wonder whether there's a wider way in which we can look at how we integrate mediation with other options, and also other professionals working in a more joined up way. So I mentioned in the last slide professionals, and Elaine has touched on this as well. It's really important to have that team, as Elaine says, around you as a client and having the right people there. And I think sometimes the mediator, the key thing is having that in mind and almost acting as a chairperson, if that's the right word, to making sure you've got the right input and the right people in the room. And we've touched already on bringing solicitors into mediation. I really hope that's a change that we see, a positive change we see moving forward, to bring solicitors in when it's helpful to do so. But there are also lots of other professionals who can help in a significant way. So bringing in a financial neutral, a family consultant, and I've mentioned there are accountants, which may perhaps seem a little strange, but I've done a mediation where both clients didn't have lawyers with them, but they came into mediation with me, and they each had their own accountant in quite a complicated case. And although we didn't quite sort it out, I think they did make some progress, being able to talk with their accountants with them about the business that they were wanting to divide, and how it might work, or whether they were going to remain as shareholders in the business. So again, it was about thinking about who was going to help to be able to take them forward and be able to make those informed choices. Evaluation in mediation. This doesn't happen all that often, but I think this is also something which has been the subject of a talk this week. I think David Emerson and Reece Taylor at number 36 talked about this as something which can happen in mediation. And again, it's something which I've done in a case where, as a last resort, in that case where my clients really got stuck, and I got someone in to give a neutral evaluation on an area which they were apart, really very much on a point of principle, and it was the key in that mediation to unlocking things. And if we hadn't had that neutral evaluation, I think there's a good chance that they may have then had to go off and either get a more expensive private FDR, or alternatively to have had an adjudication. So within mediation, we were able to get an outcome and keep everything cost proportionate. So I do think it's a really helpful thing to have as a fallback, as an impasse strategy. And then linking with other non-court dispute resolution options. I added MEDARB there as something which might be thought about, and obviously in this jurisdiction it can't be the same person, the mediator and the arbitrator, for reasons everyone will be familiar with. In other jurisdictions like Canada, for example, that is something which they do. So both mediator and arbitrator are the same person. And there are various sort of options in this jurisdiction. There's a certainty project which provides a framework for it to happen, but it doesn't necessarily have to be done according to any particular framework, and there's no particular magic to it, in this sense that if clients want to have a roadmap which avoids them going through the court process, then they can sign the ARB1 to go into arbitration, sign the arbitrator's terms, and the arbitrator can then accept the appointment and then stay the arbitration in favour of mediation. So clients then have that certainty that if they can't reach that resolution in mediation, they know what the next step is going to be. And then the mediator might encourage them to avoid a position where if they can't agree everything, that everything is then up for grabs in the arbitration. So thinking about whether or not the issues can be narrowed, and the arbitrator can then just determine perhaps some narrow issues. So for example, if clients have managed to resolve in a financial case the amount of maintenance but haven't quite got there on the term, that might be something an arbitrator might be able to deal with without hearing any evidence, and be able to deal with it in a more cost-effective way, and even perhaps just done on the papers. And of course, also, whilst this talk is entirely about mediation, not arbitration, there can be that worry about arbitration and the cost of it. But for a whole variety of reasons, it can end up being less expensive than going through the court process. And I wonder whether there will be more of a move towards this. This is an idea, clients having that feeling that they know in a certain time frame they can have everything resolved, either by way of mediation or a move into arbitration, and perhaps something which we might want to do a bit of work on is just that transition really from one to the other. And I've mentioned collab arb, and really the same, very similar principles apply. And now it's possible to do that with a change to the participation agreement. So I think perhaps if there's a top tip or a takeaway point, it's for all of us trying to think not about the non-court dispute resolution options as completely different options or silos, but really is a suite of different possibilities that can be integrated, interlocking, and really thinking about what at a particular moment in time is the thing that's going to help clients best to help them reach a resolution in a way which is conflict free and keeps costs to a minimum. Next slide, please. And Elaine.
Thanks, Tris. So just a bit of practical guidance for solicitors supporting clients in mediation. So some essential do's and don'ts. And a lot of these I share with mediation participants. Stay calm, think flexibly, and focus on the outcome. So as we know, the framework and focus for all negotiation and settlement methods, including mediation, is making proposals. So whether you're trying to sort this out with a local mediator, or you're at the United Nations trying to sort it out between countries, the negotiation is all about making proposals. So in terms of thinking flexibly, it helps to prepare a few proposals for each issue that you're trying to resolve or plan. And in doing so, you avoid all or nothing thinking, because that certainly is something that doesn't help with mediation. And also you can think about prevention of just getting upset when your first proposal isn't immediately accepted, and thinking about that any concern about the past can be turned into a proposal about the future. And that's one of the jobs of the mediator. Oh, Helen, can we just go back to the previous slide? Thanks. So play an active part in problem solving, not point scoring. This is not about making, really carefully crafted legal points. It's about everybody adopting a problem solving approach in the mediation if you're getting involved. And certainly, even if you're not directly involved in the mediation, it's something to be thinking about with your client, perhaps in between the mediation meetings. Aiming for progress, not perfection. I think in our profession, a lot of us are perfectionists, but it's okay here not to be. So, so aiming for perfection, and just think about progressing things and moving things on. Language matters. So I think Sarah was saying earlier that she'd attended one of the lunchtime sessions that Resolution's now putting on about language, and was reminded about the 5 Ps: plain English, be personal, be proportionate, adapt a problem-solving approach, as I've just said, and build positive futures. So be clear, avoid jargon. One of the tips was possibly doing a glossary so that you can help clients with some of the technical legal language, put it into plain English. Obviously, careful wording in letters helps with all NCDR. I mean, the number of times I see some really hostile letters between solicitors, which has really not helped matters. And clients actually are pretty fed up when they feel that they're, almost being drawn into more conflict by the lawyers. A shout out, of course, for Resolution's good practice guides. It's always worth remembering those and having a read of those. When I train in domestic abuse and safeguarding, I'm always concerned that through solicitors, through lawyers, generally the abuse can be continued if you are just the mouthpiece of your client. And some of those practices, sending letters late on a Friday when no one can take immediate legal advice if they need to, adopting your client's unreasonable position, these are just complete no-nos, and really dealt with in the code of practice, resolutions code of practice. This year is the year of the code. So very important just to go back to basics, read the code. I'll talk a little bit about BIF in a minute, being brief, informative, friendly, and firm. I was also really interested in the Melka Academy have some great little cards that, and this is Australian, and they've certainly been to some DR conferences, and they talk about staying on the rails. What do clients need for the long haul? So these are really good tips: process mapping, communication, 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 a manager or a go-to person, which is certainly what you could be as the lawyer, a continual sense of progress, of making progress, of knowing what the next step is, having the emotional case heard, recognised and acted upon, feeling the process is fair, and obviously care and safety. So we're looking here at finding options for mutual gain, doing cost benefit analysis with your clients, regularly telling them, giving them cost updates about how much it's going to cost if they decide to take it to court, for example. Your BATNAs and your WATNAs. So this is with grateful thanks to Getting to Yes, which is a really old but brilliant book about negotiation. So your BATNA is your best alternative to a negotiated agreement, and your WATNA, of course, is your worst alternative to a negotiated agreement. And so, in other words, what is the best outcome you might get at court? What's the worst outcome you might get at court? So I often discuss this with mediation participants to go back and ask their lawyers what their BATNA and their WATNA is. So avoid negative mind reading. I know this isn't on the slide, but this is something I was thinking about, I do see a lot of. So it's really easy to make assumptions and jump to negative conclusions about the other person's behaviour, and this includes the other lawyer as well. It's what human beings are designed to do to keep ourselves safe. But when we try to read the mind of the other person, you're most likely to jump to the worst interpretation and the wrong conclusions. The other person then feels attacked, they become defensive, and this can rapidly escalate and lead to increased conflict. So instead of jumping to conclusions about what's going on in the other person's mind, remembering, of course, that we don't wear our intentions on our sleeves, ask genuine questions, share your own reality, and keep calm. So I encourage people in mediation to share statements which include, when you do this, I feel this, and that's much less likely to make the other person feel defensive. So BIF stands for being brief, informative, friendly, and firm. There are some great books on BIF. So the one I use most often is this one, BIF for Co-Parent Communication. And so that's a great book. And what it does is it goes through about 28 worked examples of a poor communication, which is then turned into a BIF communication to make it more appropriate. So, and just to finish off on that slide, justice, as we know, and fairness are in the eye of the beholder. Next slide, please.
Thanks, Elaine. So there's a degree of overlap perhaps between the slide that Elaine's just spoken to and then what and defining success. So what does a successful mediation look like? And when in preparing for this talk, I was thinking about this, and I think it's something which different mediators may likely to have varying perspectives on. I'm interested to hear if Elaine disagrees with me when I get to the end of these slides. What I suppose what most people coming into mediation want to come out with is an outcome. So I suppose a very simple answer to the question might be, well, it's a successful mediation if clients come out at the end with an agreed set of proposals. But I think probably the real answer is a little bit more nuanced than that, because clients can come out with an agreed set of proposals, the mediation having been successful. They may get to a set of proposals, but actually after mediation that hasn't been great. So the pathway, I think, to those set of proposals is a really important one. So it isn't necessarily just all about the outcome. So I think a successful mediation is one where we do some of the things that are listed on the slide. So focusing on interests and not positions. So we don't want really in mediation just to negotiate inefficiently towards a midpoint. And years ago, I can't remember when it was, but someone at either a talk I went to or some training used an analogy, which I sometimes talk with clients about two chefs wanting to divide a lemon. And they decided just to cut the lemon in half, but actually one of the chefs wanted the zest from the lemon and the other wanted the juice. And if they'd talked to one another about what they needed for their recipe, then they could have divided the lemon in a more efficient way. And of course, life isn't as straightforward as that. And if it were, there'd probably be no call for mediators at all. But it is, I suppose, what lies at the heart of part of what lies at the heart of mediation, really, not just cutting the lemon in half, but thinking about, well, what's going to work for us? How can we do this in a way which might be different to what a judge might do, or an arbitrator might do, and make this work for us? And really, the pathway to that is focusing not on positions, but interests. And as Elaine has talked about, sort of exploring those possibilities for mutual gain. And I think in order to focus on interests, not positions, there has to be good information exchange and clients being able to participants being able to talk about what's really important to them, and that can be hard sometimes, and it's normal as we all know for misunderstandings to arise when relationships come to an end, and when trust breaks down, and information exchange is important, and particularly important, I think, perhaps, or there needs to be a particular thought given to it when we're mediating when people are in separate rooms, because it's more difficult to have that information exchange, I think, when people aren't in the same room together. And we need to make sure that we don't just rush towards trying to get to an outcome, but think about what are the steps that we need to take to get us to that point where we're going to be able to really think about what's important. And as Elaine has also said, it's so important that in mediation clients feel heard, and that they listen. They listen and feel heard. And we know how hard it can be to actively listen. And I sometimes say to clients coming into mediation, I wish I could wave a magic wand and be able to make everything okay. I can't do that. But even if they don't get to the point where they have an outcome at the end of it, if they understand better where the other person's coming from and have really listened to what the other person has said, that may be the key to unlocking or getting to a solution in another option outside of mediation. So listening, feeling heard, so important. And sometimes there are lots of techniques that mediators might use. Something I might say to clients sometimes is, you know, there may be something that you want to say immediately, but just write it down so you don't forget. And try to really think about or actively think about what the other person is saying, not what you're going to say in response. Otherwise, very quickly you stop listening. And finally, improving communication. Again, this is another area which could be a whole talk in itself. And Elaine's touched on this a little bit. Talked a little bit about BIF. Again, there'll be a whole variety of ways in which mediators might think about this. I was at a talk not so long ago where the person giving the talk talked about clients when the other person made a suggestion, agreeing that they wouldn't immediately say, I don't like that idea, or that won't work for this reason, but having to ask perhaps one or two questions in relation to the proposal before they then said what their thoughts on it was, to make them think perhaps a little bit more about, well, might there be a possibility that this might work, not immediately disregarding it. But again, communication, a talk in and of itself. But really all of those things are things mediators are going to be thinking about, not just can we get to a point where there's an outcome, but can we get to that point in a good way? And of course, that's never more important that when you're talking or in mediation with parents who, whatever the outcome, are going to be co-parenting together going into the future. And so if some of these things or all of these things can be the focus, not just the outcome, that's going to make it much more likely that they won't be back in mediation 6 months later, needing further help to try and reach a resolution. Next slide, please.
Thank you. So, thank you for that, interesting, Elaine. And one of the questions we're sort of thinking about is how could mediation be suitable for cases that you have, and have a think about that. And if anyone's got any questions, to pop in the question box. I just wanted to share as well a case from when you were speaking. Then it made me think about a case I've recently worked on with a couple over about an 8-month period. And there were expert reports required and some complications, and they reached an agreement in hybrid mediation with support from their solicitors, and having more of a joined up approach but adequately dealing with the complexities. The couple always turned up together as well and got on really well, and sometimes I looked at them and thought, why are you separating? And they said that they had a couple that they were good friends with that were also going through a divorce, and they said it's really hostile, and they'd had sight of the letters between the solicitors, and spent a fortune on the court process, and their friends had said to them both separately that they wished they'd had started mediation with their solicitors after hearing their experience, and said that they wished they'd spent more time researching their options and the solicitor as well. So I think that was just a good comparison of some feedback that I'd had recently from the two experiences.
Yeah,
So
Sarah, I can think, just thinking of that, of a situation. It was a case I did last year where the participants had spent 2 years in litigation over child arrangements, and they'd spent well over 100,000 in legal costs, and they were absolutely fed up, and they didn't feel as though they'd actually achieved very much. And so they said to the lawyers, right, just leave this to us. We're finding a mediator. We're going to sort it out in mediation. And over a series of mediation meetings, they did.
yeah, and I think it goes back to that important point of listening to what your client's journey for their separation, how they want it to do, and allow them to make an informed decision into it.
Mm.
So ahead of Family Mediation Week, the FMC had commissioned Survation to conduct a poll to gauge public awareness of mediation, and the results revealed that 66% of respondents were aware that mediation is an option for resolving parenting, financial and property matters following the separation or divorce. But interestingly, when asked which professional they would turn to first for assistance, 45% said a lawyer or solicitor, while 30% would seek help from a family mediator. And it goes back to what we're saying there. It's crucial that the first professional that someone speaks to when facing separation provides them with the full range of options available to them, ensuring that they can make an informed decision about the best. Do you have, Elaine, do you have any tips on how solicitors could better support the clients in that initial meeting?
I suppose I think about the MIAM, and I think about perhaps adopting some of the great things that happen in a MIAM would be really helpful. I think, letting clients know right at the outset that there are pre-application protocols. I know that I've been sending those directly to mediation clients, sharing that letter from the president. So trying to steer people away from assuming that court is the first option, and really emphasizing the fact that it's the last option. Again, it goes back to what I was saying about, my training was all about you do things in this order, you don't ask open questions, you ask closed questions, shut the client down really, and make sure that you tick your box that's where you've given them all the information. Well, there are definitely better ways of doing that. So for example, when somebody's really in an emotional state, they're not going to listen to what you've been saying anyway, no matter what your words of wisdom are. And quite shockingly, when I ask people and they say, oh yes, I've got a solicitor, that very often they can't even remember the solicitor's name, let alone anything else. So perhaps thinking about making sure you've got resources on your website, making sure that you've got relevant resources that you can send out to clients. I think that's really helpful. But it just does go back to the listening piece first and foremost.
Yeah. Thank you. And as both a family lawyer and mediator myself, I understand how the language used by the opposing solicitor can sometimes discourage mediation. I hear phrases at work about there's no point in hybrid mediation, just look at the correspondence, and it can create unnecessary barriers to mediation. Unfortunately, hostility between solicitors can often escalate conflict rather than help. And you'll both know that sometimes you end up in the hybrid mediations mediating the solicitors as much as the clients. Do you have any tips, Elaine, on diffusing tension when faced with a hostile solicitor on the other side?
So again, going back to the BIF books, There's a very helpful BIF book for lawyers and law offices that Bill Eddy has written. So there's some really good tips in there. You know, I think trying to focus your attention on problem solving rather than winding things up. And of course, it's really difficult. You see communication breakdown all the time. I see it even within my own family, where in a direct conversation, you can see a breakdown in communication. So when you add in the layers of solicitors' letters, that makes things really, even more complicated. So sometimes I think the simplest thing is just to pick the phone up, speak to the lawyer for the other person, not to be frightened of them or worried that something you're going to say is going to derail things. More likely than not, it's going to be a good conversation that will help you to make progress. What do you think,
Yeah.
Tris?
Yeah, no, I agree. Completely agree.
Yeah, and I always think sometimes that first letter, if you just say, "Can we have a phone call?" rather than replying, you set the tone then of dealing with it as a solicitor as well, don't you?
Yeah. Well, I think you've told me a story before now, Sarah, about you writing letters and talking to the other lawyer and using first name terms, whatever, and then getting back a letter that starts "Dear Sirs," which
Yeah.
that to me in this day and age seems really ancient practice that's gone well out of date.
Yeah, and in the Lunch and Learn this week on Language Matters, which Resolution did, they were saying about maybe ask the person, how do you want me to address you, and not using the dear sirs, and some of that, which was quite good outcomes. So I had a Mayan referral where both participants were eager to proceed with a joint mediation session supported by their solicitors. However, after suggesting professional meeting, one participant's solicitor refused to attend and disagreed with the approach. Tristan, in light of the new FM5 form, how do you think the courts would view this situation? And would the courts consider the solicitor's refusal as a failure to engage meaningfully in NCDR?
Well, I, I think the court is going to be very keen to know why the solicitor refused in that situation, because if both clients are saying this is what we want to do, if they had a really good reason, so if there were obviously if there were safeguarding concerns, or if there were allegations of domestic abuse, which meant it wasn't going to be appropriate at all, then I think the court obviously is not going to be difficult about that. But unless there's a good reason, I think that's a real shame that two clients who want to mediate, that it's the solicitor then is in the way. If I were the solicitor who had been rebuffed in that situation, I would be thinking about preparing an N260 and coming along to court with that N260 and be asking for my costs that have been incurred in respect to that issue. And I think there have been some cases, I've heard, nothing reported, I don't think, but some cases where that has happened, where people have taken their N260 along and said that the other side have not engaged in non-court specific resolution when they should have done, and we'd like our costs in respect of those that have been thrown away in relation to that issue. And I'd be surprised if that isn't an application that the courts aren't sympathetic to. What we're waiting for, I think, is a High Court decision where that kind of issue has arisen. Again, a bit above my pay grade, but I'll be very surprised if that isn't a decision which doesn't come relatively shortly. But I guess watch this space.
Yeah. We've had quite a lot of questions that have come in, so if I just address some of them. But this month's family law already highlights concerns about a two-tier system arising in relation to NCDR, given the unaffordability of NCDR options other than mediation in most cases. This is particularly relevant when there are concerns about full disclosure and power imbalances. What are your views about the risk to access to justice, Tristan?
Well, it's a problem. And LASBO has left a lot of litigants in a position where they're not represented when it would be helpful to everyone if they were. But we are where we are. I think what I'd say is that there can be a perception in relation to the non-court options that they are only accessible for those wealthier people, and I wouldn't want to minimise the fact that I totally recognise that there are some cases where it simply isn't an option, but it's rare, I think, where the court is going to be less expensive. less people, I suppose, are totally unrepresented. And so even, and again, I'm conscious we're talking about mediation, not the other options, but as it's been raised, there can be a perception that arbitration, for example, is a more expensive option, whereas in fact, if you've got what would otherwise be a 3-day hearing where people are represented, it's probably going to be cheaper in arbitration because it can be listed for 2 days because there's no judicial reading time and there's no judgment writing time built in, and then you're not paying refreshers for that third day. So you're going to have a very fully reasoned written judgment for a cost which is probably less than a 3-day contested hearing. Now, that might not completely answer the question, but I suppose it's always just it's worth not discounting the non-court options because people will think they're going to be more expensive when perhaps they might not be, and perhaps just in relation to private FDRs. And again, I recognise there's a not insignificant cost for that, but there are lots of people offering those now, so you don't need to go to a retired High Court judge. You can go to someone who's really quite junior but still an expert in their field. And when we think about, what are the chances that a case is going to resolve itself, probably much more likely in a private FDR where someone's had the opportunity to really get into the detail than in a busy court list where the judge has got 4 or 5 other cases and won't have had the chance not to think about, well, what is the answer, but also to think, how am I going to deliver the message for these particular clients to give them the best chance of reaching a resolution?
Yeah, thank you for that. Another question, how can you support a client where one party has been to a MIAM and your client has not, and your client tells you he does not want to mediate because his former partner never listens to what he has to say? How can you explain to try mediation?
Oh, well, I think first of all, to encourage your client to attend the individual MIAM and have a chat with the mediator and share those concerns with the mediator. And then the mediator can be reassuring, can talk about the possibility of sitting in separate spaces. So I start all of my mediation meetings off with people sitting in separate rooms so I can just check out how they're feeling. And very often they will decide to sit together, which has to be a decision of both of them, or they may decide to sit separately for half of the meeting, then sit together, or never sit together. But it's a way of people, if they're sitting in a separate breakout room, they will be listened to by the mediator, and the mediator will be able to convey those messages to the other person and make sure that they listen. But I set out some ground rules to begin with. So, I talk about people being respectful and not interrupting. And of course, the mediator is there to interrupt and make sure that people are able to say what they need to say.
Yeah, and I think as part of your suitability assessment, how I do is you're assessing as well if there is some room for negotiation and compromise. And if you do a MIAM with that person and they're saying, I'm not budging, then you'd be saying it's not suitable anyway than wasting time. So I think
Yeah, I talk about, always emphasizing proposals as opposed to demands, because very often that's what people will come into the mediation with, certain demands, and you just rephrase that and turn it into a proposal.
Yeah. Another one, how do you know that a client understands mediation is voluntary and confidential?
That is in all the literature that goes out to them, wherever they look, but hopefully whatever government website, and certainly all the information that a mediator would send in advance is to emphasize that point of the MIAM being individual and confidential.
I think also perhaps, Elena, if you agree, just reinforcing it. So reinforcing it in both individual meetings, and then when we come together to sign the agreement to mediate, if that's done jointly, just reminding everyone then again at that point, just very quickly what those pillars of mediation are.
Yeah, and one good question is coming about, in your experience, what about solicitors practicing as mediators appeals most to clients compared to mediators without a solicitor background? And I suppose this is for your background as well, Tristan. There's barristers that are mediators as well. Have you got any advice to that?
Elaine?
Well, obviously, mediators come from all sorts of different backgrounds, and as Tris was saying before, it's sort of horses for courses. So listening to your client and finding out what they need. I can certainly think of some of my cases where we've identified early on that there may be a communication issue in the relationship, which could be helped by bringing in a therapist or a divorce coach, or you might start with a mediator who comes from that type of background. So I like to think, we've got a fantastic profession with lots of choices for everybody.
Yeah, just to end on a statement we've had through as well is the voucher scheme has been very helpful, encouraging people to at least try mediation. And they've said, although they don't have the results of the data, I expect more cases have settled as a result. And I feel from my mediation that if people are a bit wary about mediation, you can say, well, give it a try. What for you to, the first hour and a half, 2 hours, is free through the voucher scheme. So they can try and see if there's any benefits. So I feel from my practice, there's been much more uptake on that. So thank you, Tristan and Elaine. That we've come to the end of the session. Sorry if we've not got through everybody's questions, but it is recorded on here, so you can have a look on the FMC website for YouTube, and there's lots of other sessions on there. Especially we'd sort of talked about the hybrid session that's on there. So we've just popped up on the slides now with the YouTube channel for you to have a look on there. Okay, thanks a lot for coming. Right,
thanks everyone. Bye.
Bye.